Okay. Oh, there we go. All right. So I'm back for I guess this is episode 4. Practice for exam number 4 at least. I don't know if calling these are episodes legit or not. Yeah, I guess yeah, closing in this week's the exam. I've been working through. Added a couple more slides to the PowerPoint, kind of going over a few more things. Threw in a little NEPA flowchart bonus round for the end. Um, yeah, I guess I've been kind of going back. I think the quality of the videos is getting better. The audio, I definitely like listening to the newer ones better than the older ones. And not just that the material, they're getting a little more concise, the answers and stuff like that, but also just, learning where to stand. And also, actually, yeah, I don't know. I don't know if that, like, wearing the hat, because the mic is up above. So I think my hat, like, even the bill of the hat is an effect on the audio. So I might try ditching that for this one. Yeah, let's see. Oh, got a bottle of water, so won't be dying, second half of the video or late in the round here. But yeah, I guess I'm gonna get started. Oh, got a little laser pointer action, so that's kind of neat, I guess. There you go, section 1. But so that'll be kind of cool, I guess. Not really, I don't know. But yeah, I'm just gonna get started. Just start going through this. Don't really have anything to add that's changed since the last time. It's only been a few days since the last video. But yeah. All right. Question 1. Briefly describe 2 ways in which federal lands were historically disposed. How does this history of federal land disposition and retention help explain the crazy quilt of land ownership patterns in parts of Montana and the American West? So first part for this one, I went with land grants to settlers. Series of homestead acts starting in the 1860s. I think 1862 was the first one. Lands were homestead acts allowed settlers to settle on federal lands, either for no payment, except with a little fee, or they could pay for the land as well. In some of those early homestead acts, they weren't officially homestead acts, but the preemption acts and stuff like that. And then yeah, okay, and I think there ended up being about 285 million acres that would eventually be patented out to settlers via the Homestead Acts. And then I got land grants to railroads, which like I've kind of covered pretty heavily in the past couple videos, but so those were federal government was giving out these you know chunks of land to the railroads to promote railroad building and also to theoretically increase the value of the federal lands that be retained within the railroad grants. Here we go. So, these railroad grants were given out to the railroads, and depending on which railroad grant it was and if the railroad was being built through a state or territory, these grants usually would be giving out sections of 10, 20, or even 40 miles from each side of the railroad. So extending out either 10, 20, or 40 miles from each side of the railroad of this alternating checkerboard pattern of public, private, public, private, public, private. And I believe it was the federal government retained the even sections and the railroads were given the private sections. And the federal government's, yeah, like I mentioned, federal government's idea behind this was just that, okay, so we'll give these sections out and we'll retain these sections. And in theory, these sections here, these retained sections, would increase in value as the railroad was built. And this also resulted in these landlocked portions like you see here of public land, completely surrounded on 4 sides by private, and there's roughly about 9.52 million of these landlocked sections of land today. And I guess so those are two kind of the major ways that lands were disposed by the federal government to either individuals or the railroads. Then there also are land grants to states, which I'll cover in later questions a little bit down the road here. And then, okay, so then as, they have these acts, and then as the U.S. shifts into the retention era, starting kind of with, the ball kind of got rolling with that in 1872 when Yellowstone was founded. Yellowstone National Park was founded, and then there was the Forest Reserves Act of 1891, the Antiquities Act of 1906, and then I don't know, from what I've gathered in the reading, probably the biggest contributor to the retention era would be the Taylor Grazing Act of 1934, which was followed up promptly by FDR's two executive orders. And that Taylor Grazing Act, it reserved the about 80 million acres of rangelands. They could no longer be settled upon, but they could still be leased out to grazing. And then FDR came in after that and officially, via his two executive orders, retained the remaining federal lands in the public domain from being settled upon. It could still be used by the public, but it could no longer be settled and claimed. So yeah, and then there was FLPMA in 1976, which officially declared all federal public lands would be retained within the public domain. So you have that retained, that era of retention, and then you've had these eras of public land disposition. So now you got these, you either got these large swaths of checkerboarded alternate land ownership patterns from the railroad, and then you also, outside of those swaths of checkerboarded land, you have lands now that have been claimed by settlers, as well as the state grants as well. And that's all mixed. That now you kind of got that federal retained land intermixed with all that, private settled, homesteaded land, state land, and of course the railroad grants. And yeah, okay, I guess that, and I could also get into the Jeffersonian survey system as well, and that and how it was formally adopted is that would be the way we were going to survey and administer land going forward. And maybe I should have mentioned this before I started the question or let off with this, but that was decided in the general land ordinance of 1785 is where that's when the Congress settled on we're going to use this method here of surveying and establishing the land, and essentially it broke the landscape into 36 section townships. Each section itself is 1 square mile or 640 acres, and it was 36 sections, so 36 square miles. And with I know the Homestead Act, that one of it, the 1862 Homestead Act in particular, would give the settler a quarter acre, so 160 acres, or a quarter section, 160 acres. So you could also then you could see how that would contribute to a crazy quilt of land ownership in the West and in Montana. How does the history of railroad land grants and the Unlawful Enclosures Act of 1885 help us to understand the two parts of the contemporary disputes about corner crossing and landlocked public lands? So I'm going to flick back to, here we go, railroad. So yeah, like I mentioned in the first question, railroad grants, we're given these big swaths of land across the West, Midwest, West, where, we got, the land is given out to the railroad in this alternating pattern of, and intermixed with federal retained lands. And then, okay, so how does this and the Unlawful Enclosures Act of 1885 helps to understand the two parts of the contemporary disputes about corner crossing and landlocked public lands? So, as a major component, a result of these checkerboard land distribution is, the landlocked public land here. It would just continue on for, 10, 20, 40 miles, where you'd have these landlocked sections. So the Unlawful Enclosures Act of 1885 is established, passed by Congress, and that the idea of that is to prevent, and it's, I can't remember the exact wording on it, I'm blanking there, but it's essentially to prevent an individual, or it makes it so an individual can't prevent other people from accessing or using the federal public lands for their own use, either by fence, threat, or just any means of enclosing that land, that it's ruled unlawful. It's pursuant to the property clause of the U.S. Constitution. So how does this help us to understand the two contemporary disputes about corner crossing and landlocked public lands? So to today, go fast forward to today, we have, these large swaths of this land, and then we also got, the Unlawful Enclosure Acts, which prevents people from preventing other people from entering these landlocked public lands, or closing off these landlocked public lands. So the only way you could technically, you could theoretically access some of these public lands, though, that are landlocked, would be crossing the corners diagonally. If there's no easement or road that allows you access, the only way you could do it would be, navigating diagonally across corners, which, you under the Unlawful Enclosures Act, you can't build a fence. Even if you own these sections of land, you can't build a fence that goes diagonally across the corner here. But if you were to go diagonally, from, one corner to the other, you would, theoretically pass through the airspace of this private land. And that, a private landowner is entitled to the airspace above their land. So that's where you kind of, and corner crossing, public sections of public land, is the legality of it depends from state to state. So today, we have a lot of this landlocked public land, and it's, and we've seen in Canfield versus U.S. is a good case of the application of the Unlawful Enclosure Act. But then, also the Iron Bar Holdings case versus Cape, where we had the Wyoming corner crossers, and they were found not guilty of legal criminal trespass, but they still it's still kind of it's still going on. But they corner crossed. They never touched the private land, but they did pass through the airspace above the private in order to access landlocked public land. So that's kind of the dispute there. How should someone be able to cut corners and access that public land? Okay, I think that's kind of covered. I've covered that pretty hard. And briefly stated, what is a checkerboard landscape and how did it happen? Provide one example of a management issue or challenge associated with checkerboards. Okay, so here we go. Checkerboard landscape, it's the result of the railroad grants. At least I think that's the biggest contributor to the checkerboard landscapes. Yes, once you get outside of these swaths of railroad grants, you are going to get into that, a checkerboard landscape, created from homesteaders claiming sections of land, and then also sections of land given to states via enabling acts. But the railroad grants especially, to the highest degree, I think, contributed to these checkerboarded landscapes, because it's called a checkerboard because you got these sections of public land intermixed, in a checkerboard pattern, alternating with sections of private land, in wide swaths across the western United States. And then, one management issue or challenge associated with these checkerboards, I kind of, like I mentioned in the last question, it's accessing these sections of landlocked land in order for, any sort of, resource management, or, obviously with the corner crossing case, it's recreation, people accessing that land to hunt, which, it is public federal land, and, so they think, legally they own the right to hunt that land. But, it's the accessing that land is the challenge, and, whether corner crossing is legal or not. So that would be a big management issue associated with these checkerboarded landscapes. For what purpose are state trust lands to be managed? So, state trust lands, I do have a slide with those on here, but they're to be managed for beneficiaries, which are public institutions, beneficiaries of the state, public institutions like schools, or I don't know, for some reason I can't think of I'm not really sure what else a public institution would be in a state. I guess maybe like a hospital, but I think schools, like primary, they're to be managed for beneficiaries, state beneficiaries, manage to generate revenue for those state beneficiaries, which means they could be leased to a farmer, or any sort of business that would use that land and profit from it. For what purpose are state trust lands to be managed? How did the states come to own this land, and how is it generally distributed? What is the most common and significant beneficiary of state trust land management? So, like I said in the last question, state trust lands are to be managed for the beneficiaries, which could be any range of state public institutions, but schools especially. And so, how did states come to own this land, and how was it generally distributed? So, kind of going way back to the Northwest Ordinance of 1787, which addressed the Northwest Territory area north and west of the Ohio River. So you got Ohio, Illinois, Indiana. Indiana. I don't know why. Indiana, Michigan, Wisconsin, and part of Minnesota. But that ordinance essentially established how new states would be admitted into the Union, and eventually it would extend beyond that Northwest Territory all the way to the Pacific. But it just kind of laid out how new states would be brought in. And I think one of the big things it stated was that they'd be brought in on equal footing. Anyway, and it also it addressed kind of enabling acts as well in there. But anyway, so Ohio in 1803 kind of sets the precedent with the enabling acts, which were the acts that Congress passed in order to admit that state into the Union, or what needed to happen in order to admit that state into the Union. Anyway, Ohio gets admitted in 1803, and then as their admission into the Union, they're granted one section per township. They're given one section of land per township, for their state to generate income as a trust land. And initially, those one section, it would be section 16 that they'd be getting per township in their admission. And over time, and as more states are admitted into the Union, the number of sections per township increases from 1 to 2, and that's done with that's first seen with California in 1850, where they're given section 16 and 36. So California comes in 1850, and they're getting 16 and 36, and then following California, more states are coming in. Utah comes in 1896, and they're given 4 sections per township, so they're given 2, 16, 32, and 36. And then even, following Utah, when Arizona comes in, they're given the 4 sections per township, but then they're also given, large other acreages of land for state trust lands. And, like I said earlier, schools, in the reading, like I said in, the previous couple of videos, there was, I think it mentions insane asylum, school for the deaf, dumb, and blind. And and I think Arizona ended up with 14% of their total land area eventually that was given to them as trust lands. And the most common and significant beneficiary of these trust lands is supposed to be schools. Why is most federal public land located in the western United States? Why is so much of this federal public land intermingled with state and private property? Briefly describe one management conflict or challenge that results from such intermixed ownership. So kind of going way back, you got the General Land Ordinance of 1785, which establishes the Jeffersonian survey system as going to be the going forward standard of surveying the land and administering the land throughout the United States. And then you also got the Northwest Ordinance of 1787, which establishes kind of how new states are going to be brought into the Union. But anyway, and kind of a general reason as to why there's so much more land in the East versus the West, or so much public land in the West versus the East. Got that backwards there. Would be it's climate driven for sure. You got a much more favorable climate in those Midwest, Eastern West, Midwest states versus the West Southwest. So it's a lot easier. A homesteader could support their family on a lot less acreage in Illinois, Iowa, Minnesota, Wisconsin, Michigan. Any of those real Midwest, Nebraska. Could support their family on a lot less acreage. It wouldn't be near climate's a lot more favorable for growing. Soils are a lot better. Just all those factors. So that land, especially in those earlier homestead acts, got moved in, and homesteaders were able to take root and get settled in a lot quicker on that favorable climate. And then kind of moving to the southwest, west southwest, it's a lot drier. Climate's a lot more variable. You got hot, and then you got extreme cold. It's settlers aren't going to be able to move in and take advantage of that near as easily as they would in the Midwest. And then as then the retention era comes in, which I briefly mentioned on earlier. Yellowstone 1872, Forest Reserves Act of 1891, Antiquities Act of 1906. Then the big Taylor Grazing Act and the FDR executive orders, and then FLIPMA. So as that land in the west southwest, people weren't moving out there and settling it near as fast or easily as they would in the Midwest. Well, then those retention era acts come in, and they pull all that pull that land that hadn't been settled on yet, or claimed yet for homesteading or living on. They pull that ability from that land. You can't settle it anymore, but it's still available to the public for use. But it can't be taken into the private domain. So I kind of with those acts and with that retention, a lot of that land was in the southwest and the west. That was being retained by the retention era policies. And then what was the okay? So what do we got? Okay. Oh yeah. Why is so much of this public land or federal public land intermingled with state and private property? Well, it's definitely big contributor. Number one for that intermingling, it would be the railroad grants that gave out this alternating checkerboard of private or railroad. I guess at the time it would have been railroad and public land that was retained. And then you also got the state enabling acts outside of those swaths from the checkerboarded railroad grant landscape. So you get outside that swath, then you get into the lands outside of the railroad grants. You're going to run into this, and you would also run into this too. I guess I'm not really sure how that worked, to be honest. Like say the railroad grant passed through. I might have to ask about that one. Like, what would happen, when a railroad grant passed through here, what would happen with the sections of state land? Not sure. I'll have to look into that. But anyway, so say you get outside the railroad grants, you're going to run into this. You're going to have these state lands given to the state through the enabling acts. And then you also have homesteaders in here, too. So that'll all be intermingled. And then you might have some retained public lands, too, maybe in there. So just a culmination of all these factors has kind of led to that intermingling of state or federal public lands and private lands. And like I mentioned earlier, a management conflict or challenge that results from this is access to this land, to those federal retained lands that might be landlocked, within private lands on all four sides, accessing that land, or even just establishing an easement, or even building roads. So that's definitely, and we saw that in in Iron Bar versus Holdings, or Iron Bar Holdings versus Cape, and the Camfield versus U.S. cases. How does Kleppe versus New Mexico in 1976 help us to understand what the powers derived from the property clause of the U.S. Constitution? What does this have to do with federal lands and wildlife management? So, Congress writes the Free Roaming Horses and Burros Act pursuant to the Property Clause of the United States Constitution. And, through the Property Clause, Congress has the power to make all needful rules and regulations respecting the property and territory of the United States, belonging to the United States. So, under the Property Clause, they're entitled to make all rules and regulations. In Kleppe versus New Mexico, it's determining, does that extend to wildlife as well on that federal public land? And the Supreme Court did find that it did. That the Property Clause does extend to wildlife. So in Kleppe versus New Mexico, it's the BLM. So they have the Free Roaming Horses and Burros Act. The New Mexico Estray Act comes. The New Mexico Estray Act is in play. I don't know why I'm getting into that. I don't think I need to, but anyways, this essentially Kleppe versus New Mexico essentially established that the U.S. Constitution's property clause does extend to wildlife on federal public lands as well. And maybe I should go into more detail on that one, but I have also covered, I've gone into that detail quite a bit in the previous videos. The U.S. Constitution's, and I think I'll also kind of get into it more in the next couple questions. The U.S. Constitution's property clause, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. How does the property clause help us to understand the limitations presented to those states seeking the transfer of... Did I skip a question? No. Anyway. How does the property clause help us to understand the limitations presented to those states seeking the transfer of federal land as state ownership? Provide one example of the property clause power used by Congress and interpreted by the Supreme Court. So if a state wanted to have federal land transferred over into their possession, post-enabling acts, they would need Congress approval to do so, which is a pretty good challenge. They would need approval from Congress to transfer those federal public lands to the state. And then there is, through FLPMA, there is, states can there is a transfer of land or exchange of land process, but that land that is exchanged, it's not a one-way trade, it's a two-way trade. And the lands that are exchanged in the FLPMA process have to be of equal value or in the best interest of the public. And in the book, it mentions this is really kind of only, has been in play, especially around, I think, in Nevada around New Mexico, or in Nevada around Las Vegas, where, the city's expanding and, there's the state and the government are kind of swapping those sections of land just in order, I think, to best accommodate the growing city. And that was kind of the prime example of that. But even through FLPMA, they would still have to exchange lands, which would be a challenge in itself, and it does, but with Congress, they don't even have to exchange. Congress could give the land to the state, but they might ask for a higher price in return, whether it be higher value land in return or just a high amount of money in return. So they're not, Congress isn't held to the fair exchange that FLPMA would be. Okay, let's see. Oh, and then provide one example of a property clause power used by Congress and interpreted by the Supreme Court. So if I'm gonna backtrack to Kleppe versus New Mexico a little bit here, because like Congress, like I mentioned, Congress used pursuant to the property clause of the Constitution, they passed the Free Roaming Horses and Burros Act, and and so kind of extending the property clause to consider wildlife on federal land, and the Supreme Court interprets that, and they uphold that the property clause can extend to wildlife on the federal lands. What part of the U.S. Constitution provides Congress the authority to enact the Unlawful Enclosures Act of 1885? What is the basic purpose of this act? So with the Unlawful Enclosures Act of 1885, it is pursuant to the property clause of the U.S. Constitution. The basic purpose of the Unlawful Enclosures Act is to prevent or to prohibit any entity or person from exclusive use of the federal public land, by enclosing the land with a barrier, whether that's fence or threat, or any sort of enclosure of that federal public lands. In a nutshell, what is the Supremacy Clause of the U.S. Constitution, and how would it help resolve a case involving a federal law in conflict with a state law? So the Supremacy Clause establishes that laws made from the Constitution and treaties, are the supreme law of the land. Federal, Supremacy Clause, so it establishes, laws made from the Constitution or pursuant to the Constitution as well as treaties are the supreme law of the land. In cases of state law versus federal law, the federal law is gonna supersede the state law. So we saw this in Kleppe versus New Mexico, where you had, the Free Roaming Horses and Burros Act was legal pursuant to the property clause, and then the Supremacy Clause essentially established that Free Roaming Horses and Burros Act is going to supersede the state law of New Mexico, the New Mexico Estray Law, on the federal public lands, pursuant to the Supremacy Clause. Article 3 of the Hellgate Treaty of 1855 governs the Confederated Salish and Kootenai tribes. It reads, "The exclusive right of taking fish in all streams running through or bordering said reservation is further secured to said Indians, as also the right of taking fish at all usual and accustomed places, in common with citizens of the territory, and of erecting temporary buildings for curing, together with the privilege of hunting, gathering roots and berries, and pasturing their horses and cattle upon open and unclaimed lands." What two parts of the U.S. Constitution help us to understand the legal basis of this clause, and what does it have to do with the federal public lands and/or fish and wildlife management? So, first clause from the Constitution that helps us to understand the legal basis of this would be the treaty clause. So through the treaty clause gives the president power, as with a Senate approval, to make treaties, which are agreements between two sovereign nations. Supremacy clause then establishes treaties as being supreme law of the land. So in this treaty per se, it reserves the rights that are reserved in this treaty to tribal members. So they retain these rights to hunt, fish, gather, cure salmon, cure fish on their lands, as well as open and unclaimed lands. So the Montana Supreme Court, I can't remember the year, again, I should have checked on that, established that all open and unclaimed lands would, Forest Service lands fall under that category. So through this treaty, that meant that the tribal members reserve the right to hunt, fish, gather, and they can do that whenever they freely want to. And so via the supremacy clause, supremacy clause, that means that the rights reserved in this treaty would supersede the state rights on those Forest Service lands. So a tribal member could go and hunt or fish outside of seasons on Forest Service lands if they wanted to. How does an administrative rule or regulation differ from a statute? Where are statutes and regulations codified? So a statute is written and passed by Congress pursuant to the Constitution, and they are the statutes are codified in the U.S. Code. Administrative rules and regulations are written by agencies pursuant to the statutes passed by Congress, and the rules and regulations written by federal agencies do have to undergo the APA process as well as judicial review. And the agencies just essentially, when they're writing rules and regulations, are done in order to fill in the gaps that are left, the ambiguity and questions that are left open by Congress when they write the statutes. And the rules and regulations are codified in the Code of Federal Regulations, the CFR. How does an administrative rule or regulation differ from a statute? Where are statutes and regulations codified? Why does rulemaking, the writing of regulations, generally happen? Okay, so like the previous question, Congress writes statutes pursuant to the U.S. Constitution, and they're passed in written in law and written and passed into law by Congress pursuant to the Constitution. They're codified in the U.S. Code. Federal agencies then write rules and regulations pursuant to these statutes written by Congress. They're codified in the Code of Federal Regulations. The rules and regulations also have to undergo the APA procedure and undergo judicial review in the APA procedure, and they're codified in the Code of Federal Regulations. Like I think I just said that. And why does rulemaking, writing of regulations generally occur? The writing of regulations generally occurs because agencies have to fill in the gaps and interpret the ambiguity of language used by Congress in those statutes, or even answer questions that maybe Congress doesn't answer in the statutes as well. It's kind of in order to make those rules that they have more enforceable, or to make the statutes more enforceable and to make more streamlined and make things a little more coherent. I don't know why I can't think of the word. Just to get their management objectives a little more focused, I think. As discussed in class, the National Forest Management Act, NIFMA, includes a provision related to wildlife. Forest plans shall provide for a diversity of plant and animal communities based on the sustainability and capability of the specific land area in order to meet the overall multiple use objectives. Describe the general process pursuant to the Administrative Procedure Act of 1946 that was used to write the U.S. Forest Service's diversity regulations. Why were these regulations necessary? On what legal basis could the agency's regulations pertaining to diversity be challenged by outside interest? Okay, so let's just start with the APA. First step of the APA, of informal rulemaking of the APA, would be a notice period. So the agency is gonna publish a notice of the intended rule or regulation in the Federal Register. Federal Register, for people to, so people can go in there and read it, get an understanding, get a gist of what they're proposing to do. Second step is going to be allowing the public an adequate time for feedback, comment, and so that, and that's also going to be posted in the Federal Register as well. They're going to post either, I think nowadays it's probably done, those comment periods are probably done online, so maybe like a link to comment, but they're also, in the book it mentions that those Federal Register postings would have, meeting times, locations, just everything that would, let people know how they can participate and how they can make their voice heard on that. So that, it's called the notice and comment section of the APA. So they got to provide notice and allow for public comment. And then the third step in the APA procedure is judicial review. And courts are going to review the action of the agency under the arbitrary and capricious standard. And this generally means, they're going to look at, there's three kind of questions that they kind of consider when they're looking at, if an agency action is arbitrary and capricious. Is there a rational connection between the facts found and the decision made? Is there a clear error in judgment by the agency? And is there an important issue or aspect of the decision that the agency overlooked? So let's see, why, okay, next part of this question. Why were these agency regulations necessary? These regulations were necessary, kind of going back to the last question, when Congress wrote NIFMA, they left some ambiguity in the statute. So, provide for diversity. Well, what did they mean by that exactly? So the agency goes in and they write more specific regulations to interpret what diversity meant based on the expertise of the agency. All right, and what legal basis could the agency's regulations pertaining to diversity be challenged by outside interest? An outside interest could come in and challenge, the diversity regulations under the arbitrary and capricious standard. They could say, well, I don't know how you quite got from diversity to that, to the regulation. We're going to go to court over this. I'm going to litigate you over this, and we're going to challenge that as arbitrary and capricious. I'm going to get a drink of water real quick. Ooh. It's a game changer having the water bottle. I'm making pretty good time. I think I might accidentally skipped a question, so I'll have to go back through at the end and see if I can find it, because I got another slide in here. Yeah, so this is, I guess, just a brief little intermission thing. Here's kind of a slide with just a, base, rough model, crude model of the Camfield versus U.S., not to scale. But yeah, you could see, and this was a, textbook case of, how the Unlawful Enclosures Act came into, or the Unlawful Enclosures Act was written and passed before this transpired, but it was definitely applied to this action here when it was taken to court. But essentially, yeah, so Camfield here, he owns or has at least the right to the red land, the red sections, and then here with the blue sections we got federal public land, and obviously this was a swath of land that had fallen within the railroad grants, so we got the alternating checkerboard land ownership pattern. But essentially Camfield, builds a fence that stays on, it stays on the land that he's deeded to. He doesn't build fence, it's not like he builds fence across the corners or anything like that. and his fence, so his fence is entirely on his land, but it prevents anyone or anyone from accessing these sections of federal public land within intermixed with his land. And it went to court, and they found it in violation of the Unlawful Enclosures Act. But so that was kind of how one way it could be applied, because he essentially, I think it was some 20,000 acres that he had actually, of public federal land that he had enclosed by doing this pattern. And it went to court, and it was found, unlawful under the UIA. So anyway, like I said, I think I might have skipped a question, or I maybe just kind of breezed past this, but a little more explanation there. Getting back to it, here we are. All right, what is the judicial review provision of the APA 1946? What does it mean when people say this is a deferential standard or review? What does statutory ambiguity have to do with this? Does this mean that federal agencies cannot be held accountable for their actions and decisions? Please explain with a real or hypothetical example. All right, so first, right off the bat, what is the judicial review provision of the APA? Covered this in the last question a little bit, but the judicial review provision of the APA kind of states that courts shall hold unlawful and set aside agency actions that they find to be arbitrary and capricious. So they review the actions of an agency and determine if they were arbitrary and capricious. And like I said, there's kind of three questions that they might ask to determine if an agency action was arbitrary and capricious. And this is post-Chevron. Just, I don't know, need to note that, I guess. But question one, is there a rational connection between the facts found and the decision made? Was there a clear error in judgment by the agency? And was there an important aspect or issue of the decision that the agency overlooked? This is referred to as a deferential standard or review because it's a limited, I think it's in the Calvert-Cliffs versus the Atomic Energy. I don't know. It's Calvert-Cliffs versus the Atomic Energy Commission, I think, actually. But anyway, and in that decision, the courts, I think one of the Supreme Court justice says that, arbitrary and capricious review is a limited scope of inquiry, and it's not the place for the courts to interpret. I'm getting it wrong, but it's a limited inquiry. It's a small scope of review. They're only looking to determine, the Supreme Court or the courts are only looking to determine if the agency acted in an arbitrary and capricious way. That's why it's kind of referred to as a deferential standard of review. And so statutory ambiguity then plays into that because it's as when Congress writes a statute that's ambiguous, it leaves it leaves the door open for the agency to interpret and write rules and regulations. So then it kind of lends the Supreme Court or any court, I don't know why I keep just saying Supreme Court, but it lends courts to defer to that agency expertise. Now post Chevron, that deference is definitely going to be a lot less, or going to be less so than it was before. Does this mean that federal agencies cannot be held accountable for their actions and decisions? Please explain with a real or hypothetical example. So if we go to the Northern Spotted Owl versus Hodel case, we got the U.S. Fish and Wildlife Service conducts a review on the Northern Spotted Owl in the midst of some heavy old growth timber logging. They conduct a review of they're pressured by the Endangered Species Act to conduct this review of the Northern Spotted Owl. So they gather a team of scientists, and those team of scientists take a look. They review the populations, they run studies, and they come out and say, this is it's not looking good for old Northern Spotted Owl. He's definitely at a pretty good risk of going extinct or becoming endangered. And they push for this species to be listed. U.S. Fish and Wildlife Service comes out, publishes their final findings, and deems the Northern Spotted Owl not in need of listing. And so then this gets taken to court, and it's found by the courts that the U.S. Fish and Wildlife Service was acting in an arbitrary and capricious way by not listing the Northern Spotted Owl because they didn't provide, when they came out with their decision, they didn't provide any rationale or analysis between how they made they came to the conclusion that Spotted Owl didn't need to be listed they didn't provide any, yet no evidence as to how they got to that conclusion. And in spite of what, the team of scientists and population scientists had, said. And that was even, the population scientists had even undergone peer review in their studies, and it was widely found that, everyone kind of concurred that it wasn't looking good. So they just, there wasn't that, they didn't provide a rational connection between the decision made and the facts found in that case. And it was, so they were ruled arbitrary and capricious, and they were remanded, and they had to redo the study, and I think it was that northern spotted owl was listed as endangered following that. Briefly describe one implication that may likely result from a public land law that is written by Congress in a relatively vague or open-ended fashion. So this kind of leads to, when we have, every 4 years a new president's elected. So there's a big change in the executive branch. When they're elected, they bring they bring in all these, a new cabinet. So they got new heads to the bureau, or the Department of Interior, the USDA. They got all these new heads in. It's a change of direction. So they're gonna, it's a top-down change. So they're gonna be writing new regulations, changing old regulations, throwing away old regulations, and that statutory ambiguity allows them to do that. As it allows them to write regulations, it allows them to also go in and change those regulations, throw out regulations, write new regulations. So it results, that statutory ambiguity kind of results in a large a lot of oscillation or change, big swings, pendulum swings, changing of, uncertainty in rules and regulations every 4 years. Use northern spotted owl versus Hodel to explain the arbitrary and capricious standard of review, and explain the 2 to 3 questions the court asks in determining whether an agency action is arbitrary or capricious. So, pursuant to the ESA, U.S. Fish and Wildlife Service, U.S. Fish and Wildlife Service conducts a review of the northern spotted owl species during a period of, heavy old growth timber logging. We will recheck the question actually. So, they conduct the review. They have scientists come in. The scientists suggest that the owls are going to be, in imminent danger of going extinct, and would recommend listing them as endangered. U.S. Fish and Wildlife Service decides not to. They deem them not worthy of it at the time. Provide no analysis or rational. They don't provide that rational connection. And so they're found arbitrary and capricious by the courts and have to redo the study. So, use northern spotted owl to explain the arbitrary and capricious standard of judicial review and explain the 2 to 3 questions. So the courts come in and they ask, all right, let's see here, what, when they're reviewing the U.S. Fish and Wildlife's decision, if it was arbitrary and capricious, they're going to, let's see here. Well, question number 1, was there a rational connection between the decision made not to list the species and the facts found, which said, seemed to incline, at least, that the species was imminently going to go extinct. And the Fish and Wildlife Service didn't provide any connection there. So that, I think that was really the big one that, led the courts to rule this as an arbitrary and capricious agency action and remanded them for it. And then there's the other 2 questions, clear error in judgment. You could say there was definitely a clear error in judgment, too, when they decided not to list the species, in spite of what the, their experts were saying. And then, was there an important aspect of the problem or issue overlooked? Was there something they maybe didn't consider when they were, looking to, list or not list the species? And, maybe, and it kind of seems like there maybe must have been something they didn't consider, or there was something they overlooked, because they, they came to this conclusion that the scientists didn't come to, and they didn't provide any reason to why. So that, that's kind of how the courts reviewed that, that agency action in that case. Put simply, 1 to 2 sentences, what was the Chevron doctrine, and how was it applied by the courts to a federal agency's interpretation of a law, and a rule or regulation? So the Chevron doctrine, or aka also known as the Chevron two-step, was previously used by courts in order, to determine if to defer to an agency decision. And essentially, this state, the first thing they would ask, all right, is there is there any ambiguity, or is there any questions that Congress was silent on when they wrote the statute? And if there were, then they would just automatically defer to the agency expertise. And yeah, very rarely, if the answer to that first question was yes, so there was ambiguity in there, would it be ruled not in favor of the agency? If if the answer to that first question was no, then they would just go straight to the statute answers the question, and they defer to the statute. So yeah, like I think I kind of just covered it there, but yeah, it was previously used by courts during the judicial reviews phase of the APA, and it was very deferential to courts. Decision. Okay, how does the decision in Loper-Bright Enterprises versus Raimondo 2024 change the amount of discretion generally afforded to federal agencies by the judiciary? What branch of government does this decision empower? So, elimination of the Chevron doctrine, it eliminates Chevron in the judicial review phase. So there's no longer that Chevron two-step, like I previously just covered in the last question. And so, it's going to reduce the amount of deference given to agencies during judicial review, because they're no longer just going to automatically defer to the agency if there's ambiguity in the statute. So it empowers the judiciary for sure, and to interpret ambiguity in statutes. And I know I'm not too sure. We didn't talk a whole lot about it's definitely kind of up in the air how they're gonna review now. But I know, listening to like the oral argument from the Loper-Bright case, they were talking about Skidmore quite a bit. And my rough understanding of Skidmore from listening to the oral argument, but then also from what I can recall from the reading, was that Skidmore is, I think they didn't want to say it was deferential when they were doing the oral argument, but it forces the agency to provide evidence as to why they should be deferred to, and argue for why they should be deferred to in their regulation. That's kind of so it requires a little more work from the agency to prove to the courts as to how they got that regulation from the statute. I think that's kind of the gist of what I got, and it could be completely wrong. But I think Skidmore seems to be kind of what the leading, from what I can tell, leading idea that's going to be taking over the Chevron's former spot. All right. So in a nutshell, what is NEPA scoping? So scoping is kind of just, it's reaching out to the public and other agencies to, get an idea of, the scale of effects of a potential agency action. How far is this agency action going to reach? How far do we need to consider? So it's really, scoping is, determining the connected, the cumulative, the size, what the possible reaches of an agency action are. And it's an early stage in the NEPA process, and it's really just determining how much, who is this going to affect, how much is this going to affect, what is this going to affect. And it's also, it's getting the public too. It's trying to reach out far. How is the principle of precaution, to look before you leap, integrated into the design of NEPA, and how is it implemented by federal land agencies? Please discuss Section 102 of the law in your answer. So NEPA is written, in order, it's a procedural statute, yeah. And Section 102 essentially establishes, that an agency needs to prepare an EIS if it's determined that it's going to be, the action they're doing is a major federal action, so it has significant environmental effects. And then it also kind of lists everything that needs to be considered within an EIS, the environmental effects, environmental effects that cannot be avoided, and then also, like alternatives and the environmental effects of those alternatives. And there's two more stipulations that also must be in those EISs. We haven't talked about those quite as much, but I'll just read them off. I don't really got them memorized either. It's the relationship between short-term uses of man's environment and the maintenance and enhancement of its long-term productivity. And then there's the irreversible and irretrievable commitments of federal resources which would be involved. So Section 102 essentially establishes, all right, so if you're going to be committing a major federal action that has significant environmental effects, you're going to have to produce an EIS, and that EIS has got to have this stuff in it, the stuff I kind of just listed there. And that stuff that they find there is really causing them to take a hard look at, the what's going to happen if they do this action, or if they don't do this action, or, if they do a slightly different action. It's that precaution, it's that look before you leap. It's, having them take a hard look at what's going to happen when they do this, and consider what could happen if they do it. And that was also one of those things that was really focused in on in that Cliffs versus the Atomic Commission is, because I think the Atomic Commission, they had that EIS, they did the EIS, but they didn't consider it. They wrote it, and I think they left it in an envelope and didn't even look at it. So they did it, but they didn't consider it, and that got them in some trouble in the courts. And that was, I think where they have to take a hard look at those environmental effects and really consider them. And so that, like I said, that's the look before you leap. Take that hard look before you leap and consider the effects of what you're doing or what you're going to maybe do. Why is it said that NEPA is a procedural law? What does this have to do with Section 101, Section 102, Section 105, and the role of courts interpreting NEPA? It's said to be a procedural law because, well, I kind of stated in the last question, but it's said to be procedural because, NEPA doesn't require a substantive result as long as an agency goes through the NEPA process and, if they do that required EIS, if the EIS is required, it's found that there'll be some significant environmental effects if they do the action. So they go through the EIS, they do everything they need to. And then, as long as they do that, they don't have to choose the most environmentally friendly, or environmentally concerned option. They can choose whatever option they please. I'll get into, so that's kind of Section 102. Section 102, like I said in the last one, it establishes when they need to do an EIS and what they need to include in that EIS. Section 101 is, Section 102. Section 102 is the action forcing step or section of NEPA. Section 101 doesn't require anything from the agency. It's a broad aspirational statement that essentially it's kind of just colorful language that explains the purpose of NEPA and why we should care about the environment or consider the environment while we're doing, while we're going to do an action. So Section 101 is, it doesn't require anything. Section 105 states that NEPA is a supplemental to other agency authorizations or other actions or, statutes. So it's supplemental to the Endangered Species Act, which will require certain agency substantive results or actions when they get to when they get down the road. The Endangered Species Act may require certain agency action. NEPA just requires that the agency knows the effects of the actions that they might consider. And then, the role of the courts in interpreting NEPA is essentially just to ensure that NEPA the agency followed the NEPA process. So that's why, that's the role of the courts. They're not there. I think the quote, here's the quote here too. I think this is also from the Calvert Cliffs case, but NEPA merely prohibits uninformed rather than unwise agency decision making. So that kind of sums up why NEPA would be considered a procedural act or statute. Here we go. Another repeat kind of question, but what does it mean when people say that NEPA is a procedural law? So NEPA is said to be procedural because it doesn't require a substantive result from the agency. Like I kind of just stated in the last one, as long as they do the process, they complete the EIS, they consider everything they need to in the EIS, they can choose whatever option they please. It doesn't require an environmental, an environmentally concerned option. I think that's pretty much it. Yeah. Other statutes may impose substantive environmental obligations on federal agencies, but NEPA merely prohibits uninformed rather than unwise agency action. Explain what the Supreme Court means by this statement as found in that was in Robertson versus Metho County. Okay. What does this have to do with Section 105 of NEPA? Does this mean that NEPA is an insignificant law? So, what Supreme Court means by this decision, statement is pretty much, it means that NEPA is a procedural act. It means that as long as someone, goes through the processes and is informed on their decision making, they can make whatever decision they please. Then that's where, Section 105 comes in, though, because Section 105 states that NEPA is, why am I blanking on this now? Section 105 states that NEPA is supplementary to other agency authorizations, and I used the example of the Endangered Species Act earlier, which may require or is going to require certain agency actions, especially if there's an endangered species or species of concern in the area. So that so that's kind of how that supplemental Section 105 plays in. And so does this mean that NEPA is an insignificant law? No. NEPA is it's not an insignificant law because it forces that informed decision making on the agency's part, and it also opens the agency up to a large amount of public scrutiny because all that when an EIS is published, there's lots of public comment and review on that, so it opens it up to the public as well as other agencies and other acts too. So it's so it informs the agency, it informs the public, it allows public litigation, it allows other agencies to contribute. So it's definitely not an insignificant law, even if it is just procedural. What is a categorical exclusion as used in the NEPA context? So these are agency actions that are found not to have significant environmental effects, either cumulatively or individually, and these can also be preordained via they can be written into a statute by Congress, or they can also be written. Categorical exclusions can also be created by agencies and found in the CFR as well. So it's an act that's, like I said, not to have, found to have significant impact on the environment. And generally, no EIS is required with a CE. They may need an EA might need to be completed before you can call something a categorical exclusion if it's not already preordained by Congress or the agency. What is a categorical exclusion as used in the NEPA context? What are the benefits of using categorical exclusions? And why can the use of categorical exclusions be controversial? Provide an example in your answer. So, first one, what is a categorical exclusion as used in the NEPA context? Like I just mentioned, it's an action that's found not to have significant environmental impacts or effects, cumulatively or individually. They don't require an EIS. They might require an EA if they're not already preordained by the congressional statute or by the agency in the CFR. I think that's pretty much what it covers them. And so what are the benefits of using a categorical exclusion? Well, they can, for say routine stuff, say it's basic campground maintenance stuff. Maybe they're, mowing or repairing a fence on the campground, or they're, putting in a new fire ring or something. It'll save the agency a lot of time just to be able to categorically exclude that from an EIS process, and save them a lot of time, money, and resources for something that they've done a ton. They know what could the potential effects are. They don't, and it's for the routine stuff and stuff that's small scale. They're definitely beneficial for saving time and money and resources that can be better allocated for a bigger project that would require an EIS. Why can the use of categorical exclusions be controversial? Well, I kind of mentioned this earlier. They definitely reduce the amount of, by not having to do an EIS, it vastly reduces the amount of, public input that is and other agency input that can be contributed to it. So, it bypasses that a lot. And, an example of that would have been with the Holland Lake Lodge expansion, where the lease, the people who leased the lodge or that had the lease for the lodge wanted to, propose these large expansions, new buildings, new features, new resort, new restaurant, all sorts of stuff. Really quite the development. I didn't know it was that big until I read about it. But, big development. And it was all going to be categorically excluded because it was already a designated rec site. and it was all going to be within the 15-acre lease that had previously existed. It wasn't going to be expanding outside of that, so it was all going to be categorically excluded. So, and that obviously it reduced the amount. It was pretty much taking the public involvement out of the process, and kind of a sneaky thing, and definitely one reason as to why these can be why they can be controversial for sure. Not to mention it takes it can take that look before you leap principle of NEPA out of it too. If you can just categorically exclude it, especially with a big development like that, where it would be probably a good idea. Let's to really dig in and be like, all right, there's a great Holland Lake, some really good fish in here. We got good bull trout and good lake trout. Well, maybe we should and lots of people like to fish here, and it's a great rec area, and we got access to the Bob Marshall close, and so it's definitely a place where there probably should be some serious taking a hard look at what they're about to do before they do it. Describe one real or hypothetical example of how an outside interest might challenge a federal agency's implementation of NEPA as arbitrary and capricious, as it relates to one of the following issues. There's a large list of issues here. I'm just going to go with the one that I chose, and that was connected actions. And I do have a slide for this as well. So here we go. So in this case, it was the Thomas versus Peterson case in the Jersey Jack area of the Nez Perce National Forest in Idaho. Pretty much, I pulled this one from the book, but it's a textbook case of a connected action. But anyway, so the Forest Service comes out and they announce that they're going to put in a road in the Jersey Jack area. They just conduct an individual environmental assessment for the road. And then following that environmental assessment for the road, which they found no significant impact, they issue a FONSI. Then they shortly after that, they come out with two separate environmental assessments for timber sales along that road. And for each individual environmental assessment for those timber sales, they find no significant impact. They issue FONSIs for both of them. And if this gets caught, this gets noticed, this gets taken to court. And, in the CEQ defines, the Council on Environmental Quality that administer NEPA. They have definitions of connected actions. And, the first one just is first kind of definition, automatically triggers other actions which may require an EIS, which you could argue with this, the road triggered the timber sales, which the timber sales might require an EIS. I would think that's pretty reasonable to assume a timber sale might require an EIS. But then there's also the next two which really apply to this. Number 2, cannot or will not proceed unless other actions are taken previously or simultaneously. Well, that's pretty obvious, with the timber sales. These timber sales would not proceed if that road hadn't been, the action to implement the road hadn't been taken previously. So that, that for sure qualifies this as a connected action. Then there's number 3, which says, are interdependent parts of a larger action and depend on the larger action for their justification. So, to justify building this road, they would need the timber sales. And, to justify the timber sales, they obviously would need the road. They can't have the timber sales without the road, and the timber sales justify the building of the road. And then another thing that was just kind of noted in the case file, the case for it, was that, when the Forest Service had announced the environmental assessment for the road, they had actually referred to it as a logging road in the environmental assessment. So they had planned, it's not like they'd let's put a road in there. It'll be kind of fun, get some people out in the Jersey Jack area. And then the timber sales kind of just popped up. Maybe they were out there oh, we could do a timber sale too. No, it was the idea was that this was going to be a logging road from the start. And so they came out with these environmental assessments. They segmented it up into 3 separate environmental assessments to avoid having to do the EIS and getting the public involved. And so that's kind of, definitely a connected action. And, it was taken to court over it being an arbitrary and capricious decision not to do an EIS here. And so they ended up having to, I don't think this ended up even happening then, but I can't remember. So yeah, that's kind of yeah. I mean, this is like I said, textbook case of a connected action, and the Forest Service, yeah, just in this case, tried to skirt having to do that EIS by breaking this up, segmenting it into three smaller actions that they found didn't have significant environmental effects. And I think this was also argued to be a cumulative action as well, because cumulatively altogether, this would also have a significant environmental impact if you looked at it as one. And there was also argument too, because the area was gray wolf habitat and stuff. There were some endangered species also on the table. So there was a couple other things this could have been challenged under the arbitrary and capricious standard as well. I think that was pretty much all I had for this one. But yeah, especially just these two particularly tied into this, and even the first one, like I said, you could apply automatically trigger other actions which may require an EIS. Yeah, when the road was built, the timber sales were triggered, and you could definitely argue that these would require EISs. I don't think that would be unreasonable to assume, but who knows? Yeah, I don't know. I'm not an expert on it. I should preface that this. I'm not an expert. I'm literally a couple weeks into a class here on this stuff, so I could be way off on anything here. So if there's anyone who's really doing some serious work related to this stuff, probably don't use this video as a information source. I wouldn't write a paper based off this, because some of this stuff might be way out there. Just as a notice of disclosure. Although I do pull a lot of this information from the book, textbook, I might not be applying it or interpreting it, interpreting it correctly. All right, last question here. The Bureau of Land Management just released its proposed roadmap for solar energy development on public lands. The final utility-scale solar energy programmatic environmental impact statement and proposed resource management plan amendments, also known as the West Solar Plan. The press announcement says that no solar developments are authorized through this planning effort. Proposed projects will still undergo site-specific environmental review and public comment. What does this mean, and what does this have to do with NEPA tiering? Please explain. So I guess essentially, by releasing the West Solar Plan, it's a programmatic EIS. It's a broad scale proposed. The proposed actions regional. It's a large geographic area that they're proposing in this. And I do have a slide that also pertains to this one, but it's a large geographic area that they're preparing. In this map and these circles and stuff, I haven't looked at the BLM. This is just a general idea of what a programmatic EIS versus a supplemental EIS, how those work. But anyway, they released the West Solar Plan, which is a broad programmatic EIS that covers broad scale stuff. Its overall program considers maybe some cumulative effects and the overall objectives, and addresses broad environmental concerns. And then they mentioned in this that no solar developments are authorized through this planning effort, and so they'll still have to release those supplemental EISs, once they actually figure out where they're going to be putting in solar plants. And these are going to be focusing much more, in depth, specific site-specific EISs, direct and indirect to the site, and specific mitigation factors for that site. Whereas the programmatic EIS has got those more generic mitigation factors that cover the whole, area that they want to do these solar farms, whereas the individual EISs are going to be actually at the sites where they put in the solar farms. And, an idea, this is, this falls under, what the CEQ would refer to as tiering. So they release that programmatic EIS, and then they release those supplemental EISs, and essentially it's done to, reduce repetitive discussion points in those supplemental EISs, so they don't have to reiterate large scale concerns. They can just focus on the small scale site specific stuff, and then that large overall programmatic EIS doesn't have to go near as in depth and worry about every little potential site specific thing. It can stay broad, and it can focus on the big scale stuff. So it's a time and money and resource saver, but then it also it allows it still covers all its bases, because here in the example I got on here So this would be like the programmatic. This would essentially be like what, the Western Solar Plan. It's an EIS that kind of covers a broad geographic area, and so it's large scale cumulative impacts, generic mitigation, and then you got your supplemental EISs, and this would be considered your first tier here, the programmatic EIS first tier, and then you got your supplemental EISs. So individual sites where you're actually going to be putting in your solar farms, kind of scattered throughout, and you'll do actual like specific EISs for these sites here, located throughout. I'm not sure where this one's at. I just keep pointing up there. But anyway, yeah, you'll be doing in-depth EISs at those sites, and you don't have to re-go over the broad scale stuff when you do those individual EISs. So you'll be able to save some time when you do the overall EIS and resources, and also stay looking at the big picture, and then you'll be able to focus in when you do these supplemental EISs here, where you might put in like your individual solar farms in the case of the Western Solar Plan, and that's kind of what how tiering, and the CEQ promotes tiering in order to avoid that repetitive talking points in each EIS and save resources. And that's all I got as far as the study guide's concerned. I did do a little NEPA bonus round. I pulled this map. This is from mapworld.com, I guess. So here is the flow chart we've gone over in class. So I kind of got it here. I'm just going to kind of run through. I'm going to try to run through it without switching over to the one with the answers on it and see if I can kind of work through it real quick. So number one, agency determines that an action's required, and they decide, and they start working on a proposal for it here. Number two, so they determine are there significant environmental effects, and so if we got no, yes, and this should say like maybe or just a question mark here, but anyway, so if there's no significant environmental effects, they're gonna it's a categorical exclusion. And that, like I said earlier, that could already be pre-described as in the statute or by the agency in the CFR. And so if it's already in the CFR, it's a categorical exclusion. Okay, so then it goes down. Are there any extraordinary circumstances? Maybe this is, near a wilderness area or something, or a roadless area. If that's the case, then it might, it'll go up here. I'm going to stick down here real quick. So yeah, this right here is just asking if there's any extraordinary circumstances surrounding the action, and if not, then they just have to go and publish their record of decision, their ROD. But anyway, so say are there extraordinary circumstances? Is there a wilderness area, or is it near a wilderness area or in a wilderness area? If not, or if so, then we go up here, and this would just generally ask. The environmental effects are kind of unknown. Maybe there's some, we're not sure. So, and also if it doesn't fall under the agency's like preordained categorical exclusions, this is probably where you'll end up as well. Because then here you'll conduct your own this is where you conduct an environmental assessment. You propose, conduct an environmental assessment, and then here you'll ask, all right, did you find any significant potential environmental effects in your environmental assessment? If no, you will publish. Okay, let's see. If no, oh no. Okay, so you publish your environmental assessment. You find no significant environmental effects. What's here? For some reason, I'm blanking on what this one would be. Oh, this would just be your FONSI. Your finding of no significant impact here. Then you go to your record of decision. So essentially with this one, if you don't say you're not sure, or it's not preordained, you run through the environmental assessment. If there's you conclude the environmental assessment, no significant environmental effects, then you can issue a FONSI, and you're pretty much back to where you would be with the CE. Say you do find significant environmental effects, you come up to here where it's, this would essentially establish significant environmental effects are likely or will occur. So then you publish your intent, or notice of intent to publish a EIS. You get public feedback here. you get public participation, you post it, you get some out there. You publish your EIS, then you put the EIS after you publish it out there to the public. You get public review and scrutiny of the EIS. You publish your final EIS. I think I might have combined two on accident or put one in two spots. Because then you'll have your final EIS here, I think. Yeah, so this would be your final EIS. So you get your public feedback here of your initial EIS, public feedback. Then you publish your final EIS here. Or no, publish final EIS here. Then you make the final EIS given to the public, public availability of the final EIS, the FICE. And then you issue your record of decision here. And then this will just be implementation with monitoring, as determined in the decision. And here's it kind of filled. This is it filled out and a little bit easier. So yeah, final EIS, public availability of the final EIS, ROD. And at this point, in the game, after you've signed your record of decision, this is where you can be litigated for your decision. And then up here, here's where you can see little information about the CEs. These can be described in the statute written by Congress or determined by the agency and found in the CFR. So these can be predetermined, and you can definitely tell, there's definitely a lot less public involvement over here on the CE side of things versus the EIS side of things, where you got, multiple events where public are gonna, be involved. You got public notice of intent to prepare EIS, public scoping and involvement, draft EIS, public feedback, public availability, and then your ROD, your record of decision. So there is a lot of public feedback here, not so much here, and that's where you're going to get your controversy too with these EIS, these CEs, and even with the EA, you definitely get a bit more public involvement here when you're developing your EAs and stuff like that, but it's not until really after the record of decision, with the CE at least, that you're going to be getting that notice to the public. All right, so that was number 4. I definitely feel quite a bit better at this point than I did about a week ago with some of this material, and so I think I'm going to wrap it up. Got to go to the bathroom pretty bad, but like I said, I've said this every episode, but I'm pretty much making these for myself. But if anyone else studying for this or wants to study for this, I hope it helps. I don't know. It helps me plenty just talking through this and making these videos, and I don't know, trying to make these memorize this like a script has seemed to kind of help a little bit. We'll see how I feel about it after the exam, I guess. I don't want to count my chickens before they hatch on that. Count my chickens before they hatch on that one. But all right, I'm going to wrap it up. See ya.